Hello guys, this is Olayeni Dear Kolola Daniels, popularly known as Dear Ko Spectre, and welcome to another episode of Dear Ko Talks Law. Today's episode will be our final episode on natural law, where we will discuss natural law and customary law, as well as the criticisms of natural law. In my first episode, I introduced to you what natural law is. Second episode, I talked about certain cases in relation to natural law, and today we are talking about natural law and customary law, as well as the criticisms of natural law. After this episode, we will discuss the positive law, both Hans Kelsen and John Austin's theory of law. Both of them are positive law in nature. And after that, we will also discuss the utilitarian theory of law. Afterwards, then the sociological theory of law, and we continue in that manner till the last theory of law for our set of classes. But if this is your first time of coming to my channel, then I want to say a very big welcome to my channel. Please make sure that you click the subscribe button and make sure that you click the notification bell, so that anytime I release a video of this nature which is going to be of interest to you, you'll be one of the first set of people to watch that particular video. Do not forget to follow me on LinkedIn at Dear Kolola Daniels and on Instagram at dearko_Daniels. Thank you very much as you follow me on these social media accounts. Now, going straight to our lecture for today, like I said earlier, we are starting with natural law and customary law. Afterwards, we will move into the criticisms of natural law. So while starting with natural law and customary law, we go straight to our note. As a general rule of law, a customary law that is not in accordance with the natural theory or the natural law is null and void and will not be enforced by the courts. The validity tests for customary law were used to refine and adapt customary law to enable it exist side by side with other laws, such as the constitution in a democracy. Now, the first place that we need to start from exactly is what is customary law. And I know that most of you guys are learning law for the first time and might not understand the full concept of customary law. Now, I am very sure that you have had certain customs over time. For example, when a person dies and the person died intestate, what it means to die intestate in law is that you died without a will. If you have heard that the person died without a will and the person is a Yoruba person, then you will know that under the customary law, which means that under the custom that guides the Yoruba people, where a man dies intestate without a will, it means that his estates, that is the people he left behind, or the administrators of his estates, that is the people who are supposed to share his properties, will do it in accordance with two Yoruba rules. Number one is Ori Ojori and number two is Idigi. The difference between that is that when you are talking about Ori Ojori, for example, if the man married 3 wives, 4 wives, each of the children are going to get 1 property each. That means it's going to be shared equally amongst the children. However, when you are talking about Idigi, you don't share the properties amongst the children, you share the properties amongst the wives. So if the man, for example, had 3 houses, then he had 3 wives, each of the wife is going to take 1 house, then any child that the wife gives birth to automatically will inherit the property through the wife. But when you are talking about Ori Ojori, where the man has about 7 children, each of those 7 children must have the property equally. Those are the 3 properties. Now, these are just examples of customary law we are talking about. If we get to Igbo customary law, for example, where a man dies, the property is not shared amongst the children or amongst the wife like you will find in the Yoruba custom. Under the Igbo custom, the property is shared amongst the male children. That is number one. And number two, the first male child takes a lot of properties and few properties are left for the other male children. In short, the chunk of the man's wealth is given to the first male child, and that is the Igbo customary law. If you get to the Benin customary law, if a man dies, the first son will inherit what is known as the Igiobe. The Igiobe is the ancestral home of that man. No other person can inherit that house except the first son. No other person can inherit. And then, even before the first son can inherit it, the first son must have two rituals for his father. That is two burial ritual. The first one, which is the normal one, and then there must be a second burial which only the first son can conduct, after which he then can get the Igiobe. You can see that I've been able to show you certain different customs like you can have between the Yoruba system, between the Igbo system and the Benin system. I cannot go on and on with all the systems, but I think that these are three prominent systems. This is just to show you how customary law works, so to say. However, there are certain customs that some people will say that it is barbaric. There are certain customs that some people will say does not have sense. For example, in the olden days, before Mary Slessor came to Nigeria, according to the Calabar customary law, Calabar, system, when twins are born, those twins are regarded as, I don't know, maybe devils or something. I can't tell what exactly the Calabar people call them, but they are cast into the evil forest. Imagine newborn babies thrown into the forest because there is this superstition that twins are barbaric, or twins are, I don't even know what it is that they would have said. Now, if you juxtapose that kind of customary system, if you juxtapose it in line with the natural law being what is fair, just and right, you would agree with me that Mary Slessor was right when Mary Slessor decided to abolish that custom. Now you can see that when I was talking about the custom, I started with the one that does not have problem, how you share properties, right? Then I now went to the one that is barbaric. There is another kind of custom that you will find in the Yoruba land, that is Oro. Some people say Oro is barbaric, some people say it's not. If you are talking about Oro, so to say, it is once in a year or something where they carry a particular god in a particular time of the night, and then they tell you that nobody is to see that particular god, because when you see that god, you are definitely going to die. There is this Yoruba saying that if you are not a Yoruba person, it means that you are not supposed to set your eyes on that particular god. Now, the stupid thing about it is that it is prevalent even till today. I can remember one day when I was coming back from school, I went to visit a friend in the night around 10 p.m. and I did not know that around my school they had already declared Oro. I just knew that I was walking that night and it was only me that was walking on that street. While I was walking, I started hearing certain voices. That was when I started speaking in tongues. But I did not know that they were carrying Oro. I didn't even know what it was until I entered school, the school premises. And then someone was not telling me, that's the gate man, was telling me how was I able to pass, how was I able to come into school and stuff like that. So that is to tell you that it is still prevalent till today. Do you understand that? And some people will say that that particular custom is barbaric. Some people will say no, we should not say that our custom is barbaric because it does not align with the English custom and stuff like that. But what we are learning today is basically in connection with customary law. You need to understand customary law and natural law, what is fair, just and right. Now, before I continue with the notes, while I was talking about how we share properties, especially in the Igbo customary law, I told you that they share property amongst the male children, right? Now, there is a particular recent Supreme Court case. That is the case of Onyibo versus Anakwe, and the case of Ukeje and Ukeje, where the Supreme Court held that where females are not allowed to inherit properties which their father left behind, that particular custom is discriminatory and the custom is not right. But certain other people will tell you no, the Supreme Court cannot interpret the custom of the people not to be right or not to be fair or not to be just. When you are interpreting customs are supposed to be interpreted in line with tradition, not in line with constitution. These are mentality of people. But then there are three tests that we are supposed to use if we want to know whether or not a custom is right, a custom is just, and a custom is fair. And those three tests has been outlined in my notes. The first one is the repugnancy test, the second one is the incompatibility test, and the third one is the public policy test. Now, starting with that of the repugnancy test, that customary law must not be contrary to natural justice, equity, and good conscience. You are going to agree with me that when Mary Slessor stopped the killing of twins in Calabar, that kind of tradition did not agree with natural justice, equity, and good conscience. However, if we should juxtapose that as well with this particular tradition of Oro festival or whatever it is, where you carry God at a particular time of the night and anybody who sets their eyes on that God would be killed, that also, in my own opinion, you can seem to differ with my opinion, but in my opinion, I feel that that is also not right, so to say. It's not in line with natural justice, equity, and good conscience. Now, the second test is the incompatibility test, that customary law must not be incompatible with statute for the time being in force in Nigeria, including the constitution. Now, what you are saying is this: for example, what Justice Rosevival of the Supreme Court said in the case of Ukeji and Ukeje, and what Clara Ogumbiyi, Justice of the Supreme Court, said in the case of Onyabo and Nanakwe, is that when you are talking about certain laws that says that a woman should not have the power to inherit properties, those laws are discriminatory and they go against the section of the Constitution that guarantees our right against discrimination. So you see that that tradition does not, or it fails the incompatibility test. The incompatibility test tells us that where there is a customary law that is incompatible with any statute, that means any law being in force or the constitution, that customary law will be struck down. Now, that is to tell you that Onyabo and Anakwe pa Clara Ogumbiyi JSC and Rosevival JSC in the case of Ukeji and Ukeje have come to tell us that the custom that women cannot inherit under the Igbo customary law should be and has been struck down, and therefore they can inherit in line with the constitution that guarantees right against discrimination. Do you understand that? Also, when we look at the third one, which is the public policy test, that customary law must not be contrary to the policies of the government for the welfare of the people and the development of the country. So these are the three tests that you must have in mind when you want to look at whether or not a particular customary law is against fairness, justice, and good conscience, is against the natural law. Do you understand that? And then we move on to certain cases. The first case is the case of EFFIONG OKON Ata, where a custom which granted the head of house the right to administer the personal estate of the former slave who died intestate on the ground that such slavery was incompatible with laws for the time being in force, including the Slavery Abolition Ordinance number 35 of 1916, and was contrary to natural justice, equity, and good conscience. What happened in this case? A particular slave died intestate. What does it mean for a slave to die intestate? It means that the slave died without leaving a will. Now, all the slave's property, the slave could not give it to his children or his wife. The head of the slave, is that the one, according to the custom, is that the one that is supposed to take everything that the slave has? And then the law said, no, you cannot do that. That law that says that the head of the slave takes all the property while the children would have nothing, while the wife would have nothing, is incompatible with the natural justice, equity, and good conscience, as well as, going against the Slavery Abolition Ordinance number 35 of 1916. We also have the case of INASA versus OSHODI. The court held that the ejection of an entire family from a land for the misbehavior of one of the members of the family was not in accordance with natural law. Even if it was the custom, such custom was contrary to natural justice. It is only the offending member that is to be sanctioned. So according to this case, one member of the family was misbehaving. Now, because one member of the family was misbehaving, you now decided to eject all other members, father, mother, all the children, brother, everything. You ejected all of them because of the act of one member. Even if it is the custom that yes, when one family member misbehaves in a house, you can eject all the family members, the court held that it was against equity, good conscience, and natural justice, and that law was struck down. We also have the case of EDET versus ESSIEN. The plaintiff claimed title to custody of 3 children born to another man because the bride price they had paid on the woman had not been refunded to him. The court held that this customary law was repugnant to natural justice, equity, and good conscience, and it would not be enforced. This case is very, very funny. So you have a wife, and your wife gave birth to 3 children for another man, and then you went to go and carry those 3 children of that man and said that the bride price that you paid on your wife has not been paid to you, and because of that you are going to carry another man's children into your house. That case is very funny. I don't know who advised the lawyer to do that, but I heard that it was the custom. The court held that that custom is stupid, and I agree with the fact that the custom is stupid. You know, what has the children got to do with your dispute between 2 men or mother and husband? What has the children got to do with all that? The court held that he was not to be enforced. And you also have the last case we'll be discussing today on MARIYAMA versus SADIKU Ejo. The court held that the respondent was not entitled to custody of a child that the appellant woman had for another man 15 months after she allegedly last had relations with the respondent, who was a former husband, and 10 months after the divorce was finalized. So we've looked at each of these cases, so to say, and I've given you certain examples to give you a very good understanding on customary law. You should know that every custom have their own law, but not every law that every custom would have would be valid. That is the reason you have to juxtapose that custom with the 3 tests. The first one is the repugnancy test, the second one is the incompatibility test, and the third one is the public policy test. If that custom can pass these 3 tests of customary law, then that custom will not be struck down. But if the opposite is the case, then there is a high tendency that if the case should go to court, that custom will inevitably be struck down. We then go to the last part of our note today, where we'll be talking about the criticism of natural theory of law. And you know, there are certain criticisms actually, no matter how good a theory is. In fact, no matter how good a thing is, there would always be the bad side to that thing. No matter how good it is, all the theories have their criticism. But let us look at those that criticized the natural law theory and ask, what exactly were those criticisms? The first one is that the natural law emphasizes what ought to be done and not what is done. That since the law of most countries cut across all the schools of law, what ought to be done is not always possible, because laws aren't based on natural law theory alone. Now, this is one of the reasons why I told you that Nigeria doesn't practice natural law theory. We practice positive law. However, one problem I have with natural law is that we always look at what ought to be done in almost everything. Do you understand? So when something goes wrong, according to the natural law theorists, they will tell you, was that thing supposed to go on that way, or is there a better way that it should have gone? Now, we are not looking at it from, is there a law that says that this should be criminal? No. Is there a law that goes against this? No. What we are looking at it from is this right, fair, and just? Which means, is this ought to be done? Do you understand? If we are looking at it from the angle whether or not there is a law that criminalized it or a law that goes against it, then we are positivists, because that's what positivists will tell you. When somebody has done something which is supposedly wrong, you should ask the question, what is the law against that thing? But naturalists, you don't ask the question, what is the law? You ask the question, is it right? Now, the question here is, how then do we base our law on is it right? What ought to be done? How do we predict certain circumstances that would guarantee what ought to be done? We cannot all the time predict what ought to be done. We have to predict what is done. or tell ourselves what is done, which is what the positivist will do. If you look at other theory of law, for example, the utilitarian theory of law that tells you that when you are looking at law, you should look at it from the angle of the majority. If the majority is happy, then the law is good and the law should not be struck down. Now you can see that you have a means by which you can make a law by looking at the happiness of the greater number of people. If you look at it from the angle of the positivist, then you are asking yourself, is there a law? At least you have a working modus operandi to understanding law. But when you look at it from the naturalist will tell you what is fair, what is just, what is right. We cannot tell what is fair, what is just in anticipating an incident, because all we can do is tell you what ought to be done. We don't know what incident is going to come, therefore we cannot tell you what ought to be done in anticipation. It is when the incident has occurred that will not tell you, oh, for example, the killing of Deborah Samuel in Sokoto some weeks back. No person anticipated that girl was going to die on that day. Even her herself did not anticipate that when she was sending that VN to the group chat on that day, she was going to die. Her herself didn't anticipate it. So it is when it is done, when we have finished it, the act is done, the naturalist will now look at that act and now start telling you, oh, that is barbaric, oh, that is not fair, oh, that is not right, and that is not justice. But positive law already has acted by creating a law. And what is that law? According to the Sharia law, which is written down, it says that you are not supposed to kill a Muslim for blaspheming single-handedly. You are supposed to hand over that person to the authority. You can see that positive law has gone ahead of us to make a law, but natural law, no, they will not go ahead. They will sit down. They will wait for the thing to happen. When the thing has happened, that is when natural law will now say, oh, that is not fair, that is not right. Do you understand the difference between the both of them? And that is the problem of natural law, because it keeps emphasizing what ought to be done and not telling us what is done. And then we go to the second criticism of natural law, that natural school of law says that law should be fair and just. How do we determine which law is fair and just? Is it according to the conscience of one person or the multiple conscience of every person in the public? This raises the problem of multiple or collective conscience and the question of which of the conscience or assessments should prevail. What is right, fair, just, moral and good to one person may not be right, fair, just, moral and good in the assessment of another person, even amongst people who belongs to one religion. Not to talk of a modern world or society where several new religions have sprung up in the past few centuries, each with a different view of what is right, fair, just, moral and good. Accordingly, one natural law thinker may defend dictatorship, colonialism, discrimination, bloody liberation struggle, slavery, death sentence, restriction of women's rights, an eye for an eye, racism, tribalism, nepotism as right, while another natural law thinker may say that natural law does not condone any of them and that they are indefensible. Now, this is what is known as the multiple conscience problem of natural law. The first problem is the what ought to be done problem. The second problem is the multiple conscience problem of natural law. Why? Because when you look at natural law, how exactly are we to determine what is fair, what is just and what is right when everyone in a society have different view about different things? For example, when you are talking about abortion, I personally, I am pro-abortion, which means that I think that number one, since a man has the right to his body, a woman as well should have the right to her body to determine whether or not she wants a child to grow in her body, which is also the right to privacy. I feel that it is not right for us to have a law that restricts the right a woman has to her body. That is number one. Number two, if we are looking at abortion as well, if you want to restrict a woman when it comes to having a baby, then I think that we should also restrict men, because the woman does not fertilize her eggs herself. A man who knows that he's not ready to have a baby should go and do what is called a reversible vasectomy. A reversible vasectomy is an operation that is done on a man which restricts the fertility of the sperm of the man instead of it to fertilize the woman. But you will see that when we talk about that, especially when we are talking about restricting the right of a man, men will say no, we no do, we know they do. But when it comes to restricting the right of the woman and telling her that you can have the right to have a baby or not, that's when men will start shouting, yes, abortion is this and abortion is that. For me personally, I feel that a woman should have the right for abortion, and that is only but just and fair, because if you are going to restrict a woman, then you should restrict a man so that everything can be fair. But then when you look at other natural law thinkers, they would have a separate and distinct view from what I'm talking about. Some people will say that it is not right to kill a child, and even though I recognize that when the sperm gets to the uterus and fertilizes the egg, it forms a zygote. Yes, I recognize that. However, I recognize that a human being has not been formed at that stage. I recognize that a life has been formed, but not a human being. And therefore, if the woman who is carrying that life is saying that she doesn't want to, we should not tell her what to do or how she should, take care of her own body. However, there are certain restrictions to this. For example, in the case of Roe versus Wade, there are 3 trimesters when it comes to pregnancy. The first trimester, a woman can abort. The second trimester, a woman can only abort when the government gives her go ahead. And the third trimester, a woman cannot abort at all. So if we are going to go by this rule, I feel that this rule should be applicable in Nigeria, where the first trimester, a woman should have the right to choose whatever she wants in relation to her body, whether or not she wants to have that child. But that is just my own opinion. I am very sure that as you are listening to me right now, you have another opinion yourself, and that is good. But that is to tell you the problem of natural law. Everybody seems to have different opinion. Then when we are about to make the law, whose opinion should we use at the end of the day? Should we use my own opinion? When we are looking at another area, for example, gayism, I am of the opinion that I don't see any reason why, if I have a sexual preference to have a woman as a sexual partner, why another man cannot have a sexual preference to have a man. Because we are talking about human rights, right? When you are talking about human rights means the ability for every human to have a right of choice. Are you listening? The ability of every human to have a right of choice, and my choice is a woman. If I know my own choice, sexual preference is a woman, why am I restricting another person's choice and telling him by force by fire who you must marry must be a woman? What if he's not sexually aroused by women? Why should I use my own preference as a measuring tape for him? He should be allowed to use his own preference, so to say. Do you understand? But when I say this, you have certain homophobic people who will stand up and say, dear God, you are an antichrist. Dear God, they sent you from the pit of hell. This is the devil talking. And I just laugh. But this is to tell you how we have diverse opinion in relation to issues. And also death penalty. I personally think that death penalty should be abolished. However, there are certain cases it should not be abolished. But I personally think in other certain cases it should be abolished. But there are some people that will say, no, we must have death penalty. If you kill, you must be killed. If you this, you must be this. These are issues that when you begin to discuss, you are going to have divergence. There is no way you will not have divergent views and divergent opinions as to abortion, divergent views and divergent opinions as to gayism, the LGBTQ community, divergent views and divergent opinions as to death penalty, divergent views and divergent opinions as to certain societal issues. It is normal. It is extremely normal. You must always have this divergent view. And when we get to that juncture where we do not know whether to go left or go right, and then we ask certain people, should we go left? A lot of people say yes. And then we ask again, should we go right? A lot of people say yes. The problem of natural law is that we then do not know where exactly to go, left or right, because of multiple conscience and because of multiple opinion. And with this, I end my lecture for today on natural law. We have discussed natural law and customary law, as well as two criticisms in relation to natural law. Thank you for watching to the end of the lecture. Make sure that you subscribe, like, and share the lecture video with your friends. My next lecture will be on Hans Kelsen's theory of law, where we'll be talking about positive law. I will see you in my next class.